You get hit by a delivery truck, you find a lawyer, you sue the company, easy right. Then the company's lawyer stands up and says 3 magic words, sovereign immunity, and suddenly your whole case looks like it just got teleported into a legal escape room. Here is the weird part. Sovereign immunity is not some secret loophole invented by sneaky corporations. It is actually an old idea that says a foreign government or a company owned by a foreign government cannot just be dragged into another country's courts like a regular business. Think of it like this. You cannot just sue the entire nation of France because their government-owned bakery truck ran a red light in Ohio. Sounds wild, but that is basically the legal theory being waved around when a foreign company pulls this move. In the United States, we actually have a whole law about it called the Foreign Sovereign Immunities Act, passed back in 1976. It sets the rules for when a foreign state, or a company the foreign state basically owns, gets special protection from lawsuits. But here's your first strategy, and it is a big one. Immunity has holes in it like a block of Swiss cheese. If the foreign company was doing regular commercial business like running trucks, selling products, or operating a hotel, that usually counts as commercial activity, and commercial activity is not protected. So lawyers dig into one simple question. Was this foreign company acting like a government, or was it acting like a business trying to make money? If they were out here delivering pizza or driving buses for profit, that is commercial, and commercial usually means no immunity shield for them. Another strategy is looking at where the harm actually happened. If the injury happened inside the United States and it was caused by an act connected to commercial activity here, courts often say the immunity defense does not apply because the harm has a direct connection to American soil. Lawyers also check ownership structure like a detective checking fingerprints. Sometimes a company claims to be a foreign government entity, but really it is just a private company with some government investors, and that distinction can completely change whether immunity even applies. There is also something called a waiver, which is basically the company accidentally giving up their own shield. If the foreign company signed a contract agreeing to be sued in American courts, or agreed to arbitration, they may have already waived their sovereign immunity rights without even realizing the door was wide open. Now let us talk about the human side, because clients often panic the moment they hear the word immunity. They think it means game over, but really it just means the case takes a detour, not a dead end. A smart lawyer treats sovereign immunity like a video game boss fight. You do not just walk away, you study the pattern, you find the weak spot, and you come back with the right strategy to break through the shield. Sometimes the fight even goes international, involving treaties, diplomatic channels, or filing claims through specific procedures required for suing a foreign state. It sounds fancy, but really it is just extra paperwork with extra stakes, and extra reasons you want an experienced lawyer holding the map. History even gives us some perspective here, since courts have been wrestling with these commercial activity questions for decades, refining what counts as government behavior versus business behavior. It is basically a slow-moving legal argument that keeps getting sharper with every new case. The big lesson here is simple. Immunity is a defense, not a force field. If you or someone you love gets hurt because of a foreign company's negligence, the right legal strategy can absolutely still get you justice. It just means fighting smarter instead of walking away. If you want to learn more about how all this works, or you need help finding the right lawyer for a case like this, check out our links in the description.